When courts get it wrong, why defendants win on appeal. You can be 100% right and still lose. It doesn't necessarily mean that you were wrong. Courts are not about filing briefs, then you automatically win. Court is filled with nuances and sometimes judges get it wrong. Today we break down why appellate courts exist.
Came on reading numbers, they were reading memes. We was reading filings, planning out the dream. Turn every late fee into
You're rocking with the best.
He don't skip a beat. They like how you flip stress in the assets. How you turn a loss in the last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print.
You're rocking with the best.
Gotcha, bitch. He designed the way we move our 2 cents. Thomas is the blueprint.
Break it off another hot explosive mix.
From the first lay bill to the full camp. New culture empire, watch the flag plan.
You're rocking with the best.
Turn the credit star into currency. Turn the closed door to a first key. Turn the side job to a legacy.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
They studying the source now. Supreme Elite, New Empire talk. Came on reading numbers, they were reading memes. He was reading filings, planning out the dream. Turn every late fee into case all heat. Judge bang gavel, he don't skip a beat. They like how you flip stress in the assets. How you turn a loss in the last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite Team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan. Supreme Elite Team University. Turn the credit star into currency. Turn the closed door to a first key. Turn the side job to a legacy. He beat odds, then he beat litigation. Now we teach law like a new translation. From confusion into consultation. From survival into foundation. They log in, lights on in their eyes now. Section this, law that. They reply now. He like, know your rights, then apply now. God, that's the real drip. Let it dry now. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite Team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan. From the bench to the block, he reversed that. Put the power in the pen, yeah, he birthed that. Every mind that he frees, that's a verse that. Whole culture on the rise, you can search that. Hey. Thomas is the blueprint. Write that in the sky, let the blueprint. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite Team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan.
You're rocking with the best. You're rocking with the best. You're rocking with the best.
All right. Sorry for taking too long. Had some technical difficulties. And we are here. We are back for another one. I don't think I did it, but if I didn't, shout out to the donations for last time we was live. I'm pretty sure I acknowledged you, but I'm not sure. I don't think I did. But if I did, shout out to all you. Yeah. Now, today, before we get to what we're going to get to, I want to make a pivot. Okay? I want to make a pivot. Now, if you're in the Supreme Elite Team group, you are already informed. And for those on TikTok, for those of you that on TikTok as well, you understand, and I try to inform people that in court, you never know how a judge is going to rule. You never know how a judge may rule in any specific cases. For those of you who sent me briefs, to go over or let me know what you're going to file. For those whose briefs are so lacking merits and lacking viable claims, I'm not really addressing you on this one, because when your claims are not rooted in law and in fact, you are absolutely asking for dismissal. And you're making it to the point where you don't really have any type of factual issues that you can raise beyond that will survive a motion to dismiss. Now, in many cases, well, in a few cases, I will like to highlight, and I've been through this, and quite a other few people has been through this as well. There are times where the lower courts will get it wrong. There are times where the lower courts will get it wrong. The myth that even if you do everything 100% right, that you're going to 100% win, that is a myth. I've talked to quite a few lawyers, and hell, my lawyer, she said that she won cases where she thought she would lose, and she lost cases in which she thought it was a slam dunk. Now, for those who thinks that just because you may do everything right, and if as soon as you respond, the case is not immediately dismissed, or you don't win, that one may not know what they're doing. Now, if you have a very limited knowledge of court and the nuances of court, I can understand why you would treat court as an extension of the administrative process, where as soon as you file something, that automatically you're supposed to get what you want, or as soon as you file something in court, the judge must see it your way, or the person doesn't know what they're doing, or the judge is wrong. Now, these are the nuances that I'm talking about in court, because there are factors where the judge got it wrong, the judge made an error, and there's factors where your claims were just unfound from the jump. And those are where the lines get blurry. This is where we have to take off our emotions out of it and look at the case on its merits and then judge the case from the procedural standards of the court. So let me tell you something. What if you could walk into court? You know, you raise the right defense, you apply the correct law, and you still lose at the trial stage. Now, I know there's a lot of people who has went through that. I've went through it. We've all went through it. And one of the things that I've come to realize in a few cases is sometimes when you lose, it's not necessarily because you're wrong. Now, we are not talking about what you believe is wrong or what you believe is right. We're talking overwhelming majority of case law and proper procedure actually supporting your arguments. We're not talking about the judges being wrong just because they ruled against you. Because if your factual allegations are not supported by factual evidence and relevant and accurate case law, if they are not, then you losing, it's probably because of what you've done. But if your case is accurate in controlling case law, in which I've seen a few, then I would agree with you that the judge, sometimes they get them wrong. But because the court didn't apply the law the way it's actually written, not the judge didn't apply the law because this is just your interpretation of it. See, there is a fine line that we have to toe. So let's get a little shout out in. Shout out to D. Shout out to Kenyon Mall. Shout out to Two Gutter for Radio. Shout out to y'all. So y'all, let's make sure we have a clear understanding to break this down, because most people think court outcomes about who's right. And I've mentioned this on TikTok as well. These are some of the harsh realities of court. Court is not really actually meant to be fair. And I'm going to show you today why courts, the judges, the lower courts, the trial court, can get it wrong. Now, some people still think that court really is about, well, if I was right, I would have won. Or I should have won because I thought I was right. Nope. Court is always going to be about procedure, the admissibility of the evidence, and whether the court actually followed the legal standard. See, when there's cases in which the courts did not follow the legal standard as it's written, this is why we have appellate court. If the judges got it 100% right every time, there will be no need for the appellate courts. Now, let me ask yourselves a question. What are the roles of the appellate court? If you're supposed to win 100% of the time, win 100% of the time in district court or general court and chancery court, then what are the roles for the appellate court? Because some people don't think that the appellate court, it shouldn't apply to them because they never expect the case to even get to that point. But let me tell you something. The appellate courts have jobs for a reason. Now, debt buyers. These are some of the most consistently overturned cases that I've seen. A lot. So a debt buyer, this is what they do. An account will be charged off normally, or accounts in default. They charge the account off the books. So they've already been reconciled from an accounting standpoint from that defaulted account when that account is not accruing interest, right? Right? So once they write the account down off the books, what is remaining? The contractual obligation. So since there's a contract that the defaulted borrower agreed to and signed and stipulated to judgments or any type of collection actions, what these debt buyer companies do is they'll buy those defaulted contracts from the original lender. So let's say there's a debt for, let's say, $20,000, right? What they will do is they'll buy that debt for about 4,000. But they just don't buy one. These debt buyer companies, they're just like securitization mortgages. They'll buy hundreds and hundreds and hundreds and hundreds and hundreds. They will buy hundreds of debt contracts. And what they do is they'll probably send you a letter stating that it's from a debt collection agency, or the lender may have their own debt buyer company. So what they'll do is they'll establish a debt buyer company, assign the debt, or so-called sell the debt over to the debt buyer company, go to court, get a judgment, or sometimes the borrower doesn't even show up to court, or they get into what you call a payment arrangement. And then they collect on the debt that way. Now, why is it that the debt buyers, as soon as they buy the debt, the next step is to sue you in court? Because whether they get a judgment, and that's the number one thing that they need a judgment. Why do they need that judgment? They need that judgment. It's so they can now garnish wages. It is a very dirty game that these debt buyers tend to play. It's a very dirty game. A very dirty game that they play. In many cases, they're never going to have the evidence that they need to actually prove it. So, like I said, you could be 100% right and still lose in court. That is true. That is 100% true. That's happening to me. It's happened to me before. And we had to proceed on the manner on appeal, or prior to, once the briefing was ready and they got notice, we kind of reached a settlement, or they decided to drop the case all in its entirety. As a matter of fact, this is where this came from. This is where this came from. They decided not to pursue court because they was 100% about to do it. And I sent them a letter stating, okay, if you try to take me to court on this after I already told you this is not my account, after I told you someone opened it fraudulently in my name, after I told you I don't even know how this came about. And they still said, well, we got your social security number, we got your name. I said, you ever heard of identity theft? What if a family member did it when I was in the feds? What if someone did it? What if someone, I don't know. And they didn't budge. And so I showed them Not only have you written this off the books, I don't even owe you anything from your own accounting standpoint. And if I take you to court, discovery is going to prove it. Then I'm going to countersue you. And this is why they say, you know what? All right, we catch your drift. Leave it alone. But that's not always going to be the case. In many cases, quite a few cases, you're going to have to go on appeal as well, because this is all part of the court system. Now, you got your debt buyer. They'll come with the lawsuit. Then they'll come with the claim as the proof. Then they'll come with the defenses raised. And then they'll come with the stages where the courts will actually get it wrong. These are the stages where the courts get it wrong. Because typical debt buyers, they're going to rely on a lot of raw evidence that should not be admissible at trial. And the judge will sometimes allow the case. They will allow it. And then you will have to go on appeal. And I don't mind actually going on appeal, because appeal, for me, that's kind of how a lot of my briefs are styled anyway, which are ripe for the appellate court. Now, for those who don't understand how court works, you will actually look at the appellate court as something that's a little out of your realm, because the appellate courts don't really look at our cases the way the trial court does. The appellate court usually judges based off what is the law. Was the law applied as it's written? Did the judge create a reversible error? Was the error enough to prejudice the appellee, the appellate? And these are why the courts, especially in debt buyer case, courts are often reversing these debt buyer rulings. Now, oh, it's moving slow. It's moving slow. There we go. So, of course, this McGlingley Stafford, where business and law intersects. Of course, over at the Supreme Elite team, we don't study from theories. We study from actual professionals. And even still, study for professionals or not, you still run the risk on my happens to go on appeal. It's one of those things of court. So if you are not prepared to go all the way in court, if you are not prepared to deal with the nuances of court, if you are not prepared to actually argue this all the way through in court, stay out of court. Stay out of court. Because if you don't understand the nuances of court, And if you don't understand the rules of procedure from a trial court and the appellate court, if you don't know what the judge is supposed to do, if you don't know binding case law, if you don't know controlling cases, if you don't know the things that you need to prove, just in case you got to go on appeal from a procedural standpoint, not the facts of the case standpoint, because the appellate courts, they do not look so much at the facts of the case. They look at the record and apply the law. This is why these lower courts, they're more concerned with getting the cases over with and fast. So some of these highly technical issues that people are raising in these lower courts and these lower state courts, they're going to find themselves at a disadvantage even more, because these lower state courts are not equipped to be dealing with these complex securitization, ASC, accounting, SEC filings in a state court, especially in a chancery court. State chancery courts, it's all about contract law. Article 9 of the UCC as it's applied to the state law, not the UCC that you just Google, the state law's version. And it goes over who has the right to enforce the debt. That's pretty much what state law and state court's going to be about. So I'm getting sick and tired of seeing all these goddamn SEC attach their 8K, attach this to them, attach this to the case, attach this and let the judge figure it out in court. And this is the part that you don't understand. You're going into court trying to raise these highly complex issues in the state case. Now, these cases right here show that, once again, this was an appeal on summary judgment. These are appeals. And these are why the appellate courts exist as well. You cannot walk into court thinking that all you have to do is file your response and present your claim, and then the judge is automatically supposed to dismiss the case or rule in your favor. I'm going to say it again. There's going to be times, and no one is immune from this, there's going to be times where the judge just gets it wrong in the trial court. Because if the judges were 100% correct in applying the law, which is their job to do, if the judges were 100% correct in applying the law, then the appellate courts would not have a job. Now, in many debt buyer cases, the judge is going to allow hearsay. They're going to allow inadmissible evidence. They're going to allow copies of the original debt. There's not going to be a chain of title established. The affidavits are not going to be anyone's with personal knowledge. They're not going to pass the exception to the business rule. And the judge is still going to say, hey, they presented the debt in a factual manner. Now, once the judge concludes that those defective loan documents proves their standing, it's going to be hard for the borrower to then get out of that debt, because the judge is basically saying these defective documents will be admissible at trial. And the problem with that, is if the judge rules that documents that lack a foundation are not exempted from the hearsay rule, that lacks a chain of title, that lacks undated instruments, that lacks the actual bill of sale, when the sale took place, how much was the sale for, all those evidence that they need from a legal standpoint to prove a valid debt. If the judge concludes that those defects will be admissible at trial, then they are going to rule on summary judgment in the debt buyer's favor. Because part of the prerequisites, now we talking court rules now, is the evidence submitted by the plaintiff. If it can be admissible at trial, that is the determining factor on whether their motion for summary judgment stands a chance or not. Now, any judge that allows a broken chain of assignment, does not have the actual original contract or the authoritative copy, that does not show when and where they purchased the debt, if they're only filing the original lender's copies and they still allow it, then most definitely your case is going to appeal. The appellate courts are not going to look at your facts. They're going to judge whether the law as it's written has been upheld and applied correctly. Now, this case here, Power versus Airstream, the mobile home company was ultimately awarded summary judgment and appeal. The third court affirmed that decision on appeal, finding that various state law warranty claims failed, and therefore Magnuson-Moss also warranty claim failed. So when this case got to the appellate court, the deciding factor was the warranties, the breaches of warranties and representations. The mobile home had various issues and defects that ultimately needed to be worked on at least a half dozen times. Ultimately, the plaintiff filed suit alleging violations of the Magnuson-Moss Warranty Act and breach of express and implied warranties. Now, the mobile home company was awarded summary judgment and appealed. The third appellate district affirmed that decision on appeal, right? Finding that the various state law warranty claims failed, and therefore the Magnuson-Moss Warranty Act claim, it also failed. The Magnuson-Moss Warranty Act limits the ability of manufacturers to disclaim or modify implied warranties in cases where they have offered express warranty protection. It does not create new implied warranties or otherwise modify the implied warranties existing according to state law. Rather, the Act adopts the implied warranty protections previously established under the governing state law. I find something interesting with this. I find that the appellate court looked to the state law to issue this ruling. Why are there people in my comments still saying state laws are unconstitutional? Now, and I just have a question. Why are people in my comments stating that state law is unconstitutional? So you mean to tell me this, regardless if the judge got the case wrong or not, do you mean to tell me this, that these courts are still ruling on a law that the U.S. Supreme Court has already ruled unconstitutional? Now, the court system isn't perfect, but let's not be idiots here. Let's not be stupid. Let's not be idiots. When has the Supreme Court ever invalidated state law? I'll give you a few moments to come up with that answer. When has the appellate court ever invalidated state law? When has the Supreme Court ever said state laws are unconstitutional? Where did you get that from? Now, for somebody let me know. Where did you get it? Somebody please let me know. Somebody tell me. I really want to know. Show me post in the comments a Supreme Court case that said all state laws are unconstitutional. Somebody please point. Don't get silent now. Everybody, it's not YouTube. I don't hear that. But TikTok, you're always telling me that state law is unconstitutional. Provide me a link or the case citation where the Supreme Court has said state laws are unconstitutional. Because the last time I checked, the Supreme Court has heard many cases regarding the interpretation of state law. Nah, see, this is the part. Everybody want to get silent now. Nobody, the same people that were in that admiralty jurisdiction video, the same people that was there, they never want to show up live. They never want to show up live and support their position. Oh, y'all, we got an FDCPA claim here. Freedom, TikTok. Freedom, what's up? What's up with? Appreciate you, brother. Appreciate the gift. Appreciate the lit up the finger heart, the gifts gallery. Appreciate you. But this case was a FDCPA claim for my FDCPA, y'all, Fair Debt Collective Procedures Act. Now, this was an appeal on the trial court's decision to dismiss a claim under the FDCPA against the defendant law firm. So you mean to tell me that the defendant had a law firm? It looks like they brought the claim under the FDCPA, and the trial court still overruled them, still dismissed the case. So the trial court dismissed the case, right? Cool. Plaintiff alleged that the law firm's filing of a lawsuit on behalf of his client against plaintiff violated the FDCPA. Wow. The trial court disagreed and plaintiff appealed. On appeal, the 8th Appellate District Court affirmed, finding that the plaintiff failed to properly allege a violation of the FDCPA. That is a claim. That is a procedure claim. Now, Citizens Bank versus Deutsche. This was an appeal of the trial court decision to grant lender summary judgment in a foreclosure lawsuit. What is the common denominator here? All these cases, what are they saying? What are these professional attorneys saying? These professional attorneys are saying, hey, appellate court, the lower court got it wrong. The lower court got it wrong. These are law firms that are saying that. The lower court judge got it wrong. So once again, if you think that the courts can't get it wrong, you've lost your mind in my book. Because if the lower courts can't get it wrong, then why are there appellate courts? Can someone answer that question? If the lower courts cannot, if everything they say 100% of the time is 100% accurate, then why do appellate courts exist? As a matter of fact, let's just, hold on. Let's ask, why do appellate courts exist? Let's just see do a quick Google search on it. Let's do a quick Google search on it. Why do appellate courts exist? Appellate courts exist to ensure that the law is applied correctly and consistently across the judicial system. So what is that saying? The appellate court is saying if the lower court did not apply the law correctly and consistently like we've already held, you bring it up to us, and if it fits the standard, meets the standard, we will correct it. Why does appellate courts take so fast to rule on these issues? Because if the appellate court has already ruled in the same issues that's similar to the ones you're bringing up, and they already have state Supreme Court precedent, and the Supreme Court said this must happen if you want to bring a claim, that you must do this if you want to collect the debt. If you don't do this, it's case is subject to dismissal. So if the lower court does otherwise, the appellate court is going to see that. And the appellate court, that's where the controlling cases are at. So it's really nothing to talk about after that point. While trial courts focus on determining the facts of a case, appellate court serves as a safeguard to review the fairness and legality of those proceedings. So, as I said before, the appellate courts does not really view the facts. I've seen people with appellate briefs, and I don't know if they read the rules, the rules of the appellate procedures, but their appellate briefs, all they're doing is just restating the facts in their trial court. They don't say how the judge erred. They don't say how the law is applied. And you're basically asking the appellate court to be the fact finder, the trier of fact. And the appellate court's jobs, they're not there to find the facts. They're there to review the procedure, apply the law, make sure the law was applied correctly. Did the judge err in viewing this law this way? Did the judge commit reversible error by allowing this evidence to be admitted when it didn't pass the rules of the procedure to be admitted? Did the judge allow inadmissible hearsay records to serve as to substantiate the debt buyer's claim? That's what the appellate court is going to decide. The appellate court's not going to decide whether you're right or wrong. Ladies and gentlemen, court is never about right or wrong. Remember I told y'all court is never fair? Court is never about what's right and what's wrong. It's never about that. It's really not about that, especially in civil court. Civil court is about the facts. It's about the facts of the case and how the court interpret those facts under the legal standard. The primary functions include correcting errors. They review challenges to trial court's decisions to identify, as I just said, reversible errors, legal or procedural mistakes significant enough to have impacted the trial's outcome. Ensuring uniformity. They harmonize different interpretations of the law by trial courts, ensuring that legal standards are applied consistently within their jurisdiction. So you can't have a judge ruling in favor in this case, then you got the next case with the similar elements and they're ruling differently. That's not consistency. Developing legal precedents. Their written opinions clarify ambiguous laws and establish binding precedents, case law that guide future decisions in lower courts. So once again, if you have judges that are bound by controlling cases and the judges still rule differently than those controlling cases, and you have all the facts, evidence, rules of procedure, then I'm going to agree with you that yes, the judge was wrong on that one. The judge I ain't gonna say wrong. The judge created a reversible error. As a matter of fact, all the remedies that borrowers got in court, I'm going to, from what I've read and seen, I'm going to say about 80 to 90% came on appeal. 80 to 90% of borrowers' remedies always comes on appeal. And I know it sounds like, well, that's a lot, but you got to think about it. There's millions of cases being filed all year. It's not just about you and your case and your circumstances. Many cases are being filed every year. And cases have to go on appeal. Checking judicial power. They provide oversight for trial judges, ensuring they adhere to established laws rather than personal discretion. That is one of the biggest issues right there. Sometimes the judges ignore established law. Well, why would they do that? That's a question that no one can answer. Judges sometimes apply personal discretion over established law. I've seen it a lot. Managing caseloads. Intermediate appellate courts relieve the burden on the Supreme Court by handling the vast majority of appeals, which often allows highest courts to focus on cases of major constitutional public importance. Now, unlike trial courts, courts do not hear new evidence or witness testimony. So whatever that was in the trial court, that is what they're dealing with. So if you have a brief, a motion, and you lost a trial or a summary judgment, and you felt that the judge got it wrong, and you file an appeal, if while filing your appeal, you come up with a new argument that you didn't raise down in the lower courts, you cannot raise that on appeal for the first time. I know that's a tough one. The trial courts do not use a jury. Instead, they're decided on a panel of judges. Yeah, I think y'all should know that. And the appellate courts do not retry the facts of the case unless the trial court's findings were clearly erroneous. Now, the typical grounds for appealing the lower court trial decision, and what are these? What do they have? Grounds for appealing the 7Ks, personal injury, family court. Okay, so these are law, family court, and all. Okay, these from lawyers. Errors of law. This is going to be one of the main things. Errors of law. These occur when a judge misinterprets or misapplies the law. Now, one may ask, that's a judge. How could the judge misapply or misinterpret the law? They do all the time. They're not perfect. They're still humans. They do all the time. These are why appellate courts have jobs. Incorrect jury instructions. Incorrect jury instructions can have a major effect on how the jury weighs the facts of the case. Giving the jury flawed or misleading legal guidance. That is a reversible error. Improper evidence ruling. Admitted evidence that should have been excluded, such as hearsay, which I was going over before I opened this up, or excluded evidence that should have been allowed. That is a major one. Remember, when you are arguing cases like debt buyers, your job is, the burden does not legally shift to you unless they satisfy the prerequisite burden on their end. The judge can't shift burden onto you unless they satisfied all the elements of their burden. So if the judge shifts the burden onto you without the plaintiff satisfying their burden, that is a reversible error. Misinterpretation of statutes, applying the wrong legal standard, or failing to follow state statutes, such as in child custody or property division cases. That's the first one, errors of law. What's the second one? Procedural errors. These involve failures to follow established court rules or trial protocols, lack of proper notice, failing to provide adequate notice of hearings to all parties. Well, that's kind of a given. Jury selection mistakes, that's a given. Discovery violations, mishandling the exchange of information before trial. Number 3 is a common one, abuse of discretion. Judges have broad judicial discretion for certain decisions, like admitting specific evidence or granting motions. An appeal may succeed if a decision was arbitrary, unreasonable, or capricious. Now, an abuse of discretion is another one, because the judges, they do have broad discretion on interpreting the law, but they cannot interpret the law any more than the way the law is written. And they cannot rule on a case that's similar to a case where the appellate court or your state Supreme Court has already ruled. That is an immediate reversible error. Now, constitutional violations. Now, with a gray area. Now, this is a difference between your constitutional violations actually being violated and you believe your constitutional rights were violated because you don't like the ruling. That's the gray area. That's the gray area there. Now, due process, denying a party the right to a fair trial or the opportunity to be heard. I don't see how they will violate this much. I think the judges are kind of crystal clear, and make sure you have a right to a trial and you have an opportunity to be heard. I see that. I don't see that being violated a lot. If you've experienced that, put it in the comments and I'll read it. I'll check it out. But I really don't see that becoming a major issue. Yeah. Darren says so they can regulate and monitor lower court decisions. That's exactly what they're doing. Oh, yes, sir. Yes, sir. They don't let the judge just do whatever they want now. They don't let the lower court judge just do whatever they want. Now, the right to counsel, ineffective assistance of counsel where an attorney's poor performance prejudice the outcome. That is a tough bar. That's a tough bar. That's going to be, once again, just another this whole section, constitutional violations, is a gray area. I really don't get into those because those violations are pretty much cut and dry. Like, let's say your lawyer, they made a statement that your lawyer should have objected and your lawyer doesn't object, or your lawyer doesn't challenge the submission of evidence, or doesn't file a Brady material on your behalf when you ask them to do, like, stuff like that. I don't see many lawyers making those errors. Unlawful search and seizures, evidence obtained in violation of the 4th Amendment. Now, out of the due process, right to counsel, unlawful search and seizure, I can see that being a lot of reversible errors because they do cut corners or rely on just the affidavit and testimony of whoever's getting the search warrant. They may lie, they may manipulate, they may, run game on the judge to get the search warrant. I'm not saying they don't do it. I know it happens. Now, number 5 is factual errors. While appellate courts rarely second-guess a trial judge's or jury's finding of fact, they may intervene if a finding was clearly erroneous and unsupported by any evidence in the record. Once again, that's the allowing of inadmissible evidence to stand as evidence. Y'all, Let me tell you one thing about, what is that? Summary judgments. Let me tell you something about those. A plaintiff's summary judgment, say like in a debt buyer case, their summary judgment will only stand if at trial, the evidence, which is probably going to be the note, probably the mortgage, copy of the original lender's loan documents, if the judge rules that will be admissible at trial, then 9 times out of 10, their motion for summary judgment is going to be granted. Just because they pop up with an affidavit doesn't mean everything on the affidavit is true. Who presented the affidavit? Who has personal knowledge? How are the business records stored? When was this record created? All of that. Do you have personal knowledge? Do you have personal knowledge? Are you just the one person that handles the paperwork processing? And do you just write an affidavit? And a debt buyer, what evidence is being produced that you purchased the debt? An authenticated bill of sale, not a computer printout of the account. And just because they filed something that shows your account on it, how did you acquire the account? When did you acquire the account? Like all that. Important requirements. To successfully appeal, an appellant must typically prove prejudice. The error must not be harmless. And this is one of the biggest scams in our judicial system. Yep, I'm going to give you one of the biggest scams in our judicial system. One of the biggest scams ever in the judicial system today is when the judges created what we call the harmless error. Meaning, we agree, and I've seen courts rule, we agree with the defendant that the judge created an error, but we consider this error to be harmless. A harmless error means, yeah, the judge erred, but it wasn't enough to that error wasn't enough to affect the outcome of the case. Basically, that's them saying the case still would have came to the same conclusion whether or not the error was made. Now, when the judge makes an error that affects the outcome of the case, meaning when the judge allowed inadmissible evidence to stand as fact, which is one of the key elements of a motion for summary judgment, that's a reversible error. And if, like what I did, when you move for a motion for summary judgment too, like if you was to move for a motion for summary judgment too, and you go on appeal and you get their granting of their motion for summary judgment reversed, that is a automatic win on your motion for summary judgment. I tell y'all, man, a lot of you defense people, y'all gotta stop just responding and letting it be. You got to be aggressive. You can't just respond to the complaint. Let me tell you this. If you're responding to a complaint as a defendant, and by the law as it's written, you don't feel that they met the burden, why are you not moving for summary judgment on your own? Is the Supreme Elite team the only group that actually files for summary judgment?
You're rocking with the best.
Get your summary judgment on the record. Because if you got to go on appeal and the judge rules in your favor, then as a matter of law, your summary judgment it's going to be granted. See, that's the wherewithal of that comes with experience. But that doesn't necessarily come to experience as much as it comes with just knowing how court rules and procedures and the burden that they have to meet. Anytime a party does not feel like the other side didn't meet the burden, they're going to move for summary judgment. So, defendants, if you feel like they didn't meet the burden, why aren't y'all moving for summary judgment too? Why aren't y'all moving for summary judgment too? Would you think summary judgment is only for them? Summary judgment is for you too. Summary judgment is for everybody. And this is the stuff that I'm talking about. These gurus, they teach y'all, they come and teach y'all, but they're not teaching like the in-between strategies, these in-between motions. Now you got the complaint, you got your response. Okay, that's a given. Number 1 and 2. But where's your in-between strategies at? Where's your in-between motions? Where's your motion to strike evidence? I'm always seeing motions filed by them striking y'all evidence or y'all filings or y'all pleading. Where's your motions to strike? Not a motion to strike the promissory note. I don't even know, like, who came up with that? It got to be the pro se space. You can't file a motion to strike the promissory note. I mean, you can file whatever motion you want, but it's not legally sound. Typically prove the prejudice and preservation. The issues generally must have been raised through an objection during the trial to be eligible for appeal. Now, I'm going to tell you this, y'all. I'm going to tell you this. If you're filing, when you go on appeal, right? When you're going on appeal, even before you file your response in the lower courts, do not rush to just slap a motion together. Make sure you gather all the facts, all the evidence. Make sure you consult your court rules and procedures like it's no tomorrow. Remember, and this is the mindset you got to start taking in court. It's not you against them. See, you're trying to argue and defend against them. See, you're trying to attack them. It's not about them. You have to attack the evidence that they're presenting. It's you against their evidence. You attack their evidence. That's what you do. You attack their evidence. I'm telling you, you don't do anything else. You got to attack their evidence. Y'all be thinking it's about like you and them. It's not about, forget them. Leave them out of it for a second. Like right here. In this, hold on. Let me get down to here. So here we go. In case here. Therefore, Chase filed the submitting records evidence that it had the right to enforce the note on the date the complaint was filed. Bank that failed to file a foreclosure complaint against homeowner did not show that in fact that it possessed the note at that time. Although the bank ultimately submitted the promissory note with the undated specific endorsement to the bank provided no information as to when such endorsement was made. Therefore, we reverse summary judgment and corresponding finding judgment of foreclosure or remand. In order for Chase to be entitled to summary judgment, it must show without genuine issues of material fact that was the holder of the note. By contrast, its evidence shows that the note was endorsed to Chase afterwards. then Chase had no standing at the time to even file the complaint. Reverse, remand it. Reverse, remand it. That's all I see. I got about 350 cases. 350. Full closure. Reverse. Remand it. Debt by reverse. Remand it. Debt by reverse with an order to dismiss with prejudice. Reverse. Auto. Reverse. Reverse. Remand it. 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 Everything's remanded. To the point that you don't even get your remedy in many cases unless you go on appeal. That's the way a lot of it's looking like. A lot of it's looking like. A lot of it looks like you don't get your remedy unless you go on appeal. Y'all, when I say I have over my files, I have 15,000 files just dedicated to legal. Like finance, like civil, mortgage, auto debt. 15,000. Case law, briefs written by professionals, briefs and discovery requests from the ex-SEC attorney, books and stuff that they read, handbooks and memos written by ex-judges, memorandum and what you call it? It's besides what you call it? It's when a person just getting your words and thoughts out. What they call it? God damn it. Manifesto by ex-judges. 40 years retired. Explaining why judges get it wrong. Why a lot of times you got to go on appeal. This is not nothing new. So I'm not saying, and I'm only talking to the people. I'm not talking bringing these soft sick claims and you want to go on appeal with them. I'm talking about in cases where the judge actually got it wrong. Now, even my soft says, y'all know the judge get it wrong too. Y'all believe they all wrong. So y'all understand this. To challenge the trial court's decision, an appeal must show two things. The trial court made a legal mistake and that mistake affected the outcome. There you go. See, not the harmless error where the error didn't affect the outcome. The legal mistake the judge made, not following controlling case law, not applying the law correctly, allowing inadmissible evidence to stand as fact. See, those are the things that will affect the outcome of a case. Winning an appeal is difficult. In California, well, this is from the state of California, fewer than 20% of civil appeals succeed in changing the original decision. This is because the Court of Appeal assumes the trial court's decision was correct unless the person appealing, the appellant, can prove it was wrong. So that's that appellate burden right there. You have to prove that the judge got it wrong. To win, the appeal must include a strong legal argument that clearly shows the trial court made a mistake and that it harmed the appellant. See, there you go right there. Even though this is California, this is going to be universal throughout all 50 states. It's going to be the universal standard. You notice how, you know what these gurus will always tell people to do on appeal? They'll tell them to file an appellate brief based on the facts of the case, based on their own understanding. Well, what if the guru's understanding is flawed? What if the guru had you filing things that were wrong from the beginning in the trial court? You ever think about that? This is why I say, if your guru is not teaching from professional documents, professional literature, run 5,000 miles away from them. Because the way these spaces are these days, very few people's interpretation I would trust. And no shade to those who has correct interpretation, but the ones like myself who understands how to interpret case law correctly and not based off feelings and facts and what I want to be true, we are the minority. I mean, you still got people arguing foreclosures like we're still in 2008, thinking that the securitization as a legal defense is now, it's still a good argument to make. How many people here, put a 1 in the chat if you think that, TikTok, put a 1 in the chat if you think that securitization is a viable defense to a foreclosure. And don't just, if that's what you feel, just that's what you feel. Put 1 in the chat. And I'm doing this for a reason. I'm not trying to put you out there or nothing. Because maybe I can change your mind. There you go. True Hebrew. There you go. True Hebrew, stick around for a second. And True Hebrew, what state are you out of? We'll use you as an example. True Hebrew, what state are you out of? Stick around. Let me know what state that you're out of. Go ahead and put it in the chat. Let me know what state you got on. Now, usually an appeal will only succeed if the appellant or their lawyer pointed out the issue during the trial to save it for appeal. So he's in Tennessee. All right. All right. He's in Tennessee. No particular county is needed. We'll go with the whole state of Tennessee. All right, y'all. So we about to do a case study live online. We're gonna do a case study. Okay, so he's from Tennessee. He live from Tennessee. Okay. So let me look into my files, pull it up. So we have Brother Hebrew out of Tennessee, right? Is out of Tennessee. Now, we are going to, I'm going to break down. Now, he thinks that, well, his assertion is, I'm not going to say what he thinks. He thinks that, well, his belief, let me say it as it stands now, his belief is that securitization is a valuable argument, for a mortgage foreclosure. Okay? Now we read cases. So we're going to do this study right now. All right, for those just joining in. Yeah, just joining in. Okay, so we have in the Tennessee, we got a brother that believes today that a securitization argument is good enough to stop the foreclosure. Now, we're going to go to 2024. We're going to go to 2024. Okay? Now, let's read this. Let's read this. If we can get the goddamn document up. All right, here we go. All right, here we go. Woo, this is 23 pages. Okay. This is 23 pages. Okay. So let's get to the meat and potatoes. Let's get to the meat and potatoes of this. All right. In this Terry case, and I want to find the one he's talking securitization. Because this case doesn't seem like he's arguing securitization. So let me go. I'm gonna get a securitization case. All right. Okay. Do you think fraudulent breach of contract is good too? Is fraudulent breach of contract, is that about it? Is that pretty cool? Fraudulent breach of contract? Is that a good one? If that's a good one, just let me know. That'd be cool. Okay. All right. You know what? We'll do the Terry case, because Terry believes that in this case right here, Terry versus, let's go here, wrongful foreclosure. And this is Terry versus Wilmington, Delaware Trust Company, 2024, Tennessee. And this is out of, I don't know what county in Tennessee, but anyways, doesn't matter. So the foreclosure is, the next question for the court is whether, let me go up for a second. Let's stay right here, because I'm on the case right here. I'm on the case right here. I just want to make sure I'm not going over claims that are kind of irrelevant. I want to stick to the notable claims. Like, let's go with wrongful foreclosure. B, next for this court to answer is whether the remaining claim for wrongful foreclosure is actionable under Tennessee law. Based upon the following review and analysis, we hold that it is not. Now, I'm going to say it again. The next question for this court to answer is whether the remaining claim for wrongful foreclosure is actionable under Tennessee law. Based upon the following review and analysis, we hold that it is not. We decline to recognize a common law cause of action for wrongful foreclosure in Tennessee. Say it again. We decline to recognize a common law cause of action for wrongful foreclosure in Tennessee. For a cause of action to exist, its recognition generally must be supported in the history of the state's decisions. You got West versus Media General Government. Recognizing an action under Tennessee law for false light invasion of privacy based on the analysis of Tennessee case law. That's statutory law. They don't even have a common law action, right? Okay. Now, let's get right here. The purported explicit recognition of a direction for action for a wrongful foreclosure by an appellate court in Tennessee did not occur until 2015. In Gardner, the Tennessee Court of Appeals relied on Overhaul for the proposition that wrongful foreclosure could be asserted as a primary cause of action when a mortgagor asserts that a foreclosure action is improper under a deed of trust. The Federal District Court for the Middle District of Tennessee has also relied upon the Gardner analysis of the Overhaul opinion for the proposition that Tennessee law recognizes a distinct cause of action for wrongful foreclosure. See Beasley versus Wells Fargo. See Beasley versus Wells Fargo for certificate holders. Right? And that Beasley versus Wells Fargo, we are going to highlight that one because I believe that's going to be a good case. However, we disagree with the Court of Appeals in Gardner and subsequent citations there too, as to its analysis of the opinion of Overheard. So now you got judges disagreeing with judges. Sheesh. The Overheard decision involved a bank refusing to accept a late mortgage payment from the borrower. Overheard, that's the case. The borrower have appealed the trial court's denial of relief from a wrongful foreclosure under the deed of trust. The court found that the bank had been lying in wait for the borrower to commit a technical error so it could foreclose on the property. The borrower's agent attempted to deliver a check by hand one day after the monthly due date, which the bank refused to accept. Damn, a day late and they refused to accept? Oh yeah, they definitely laying in the cut. The court's decision hinged on whether the bank had complied with the acceleration clause contained within a deed of trust in light of Tennessee law regarding the tender of payment after default on the mortgage. The deed of trust at issue stated the first payment and succeeding payments due on the same day of each succeeding month until the entire principal and interest is fully paid. Said payments are in series, and default in any payment when due shall, at the option of the owner of said note, mature the remaining indebtedness unpaid. The court held that Tennessee law required a mortgage holder to accept the payment when it's made at the default, but before the option to accelerate the note exercise. So based on this analysis, the court held that because the bank had not clearly exercised its option in compliance with the deed of trust to accelerate the note at the default and before the borrower tendered payment, the bank had been bound to accept such payments. See, that is kind of the gist of that. Now, we're still on this Gardner case, right? And we're looking at it. The said borrowers who believe, here we go. In this case, summary judgment was entered against Mr. Case to his breach of contract for failure to establish a breach of the deed of trust or any related damages. This ruling was not raised as an issue in either this court or the Court of Appeals. And Mr. Case counsel agreed at oral argument before this court that he was no longer pursuing a breach of contract claim. Mr. Case also included claims for slander of title and to quiet title in his operative complaint. However, those claims were dismissed by the trial court, and Mr. Case did not appeal that decision. So y'all slander a title, quiet title, those are not things that easily win. You're talking about getting the whole back of your name free and clear. They're not about to let you get off that easy. There is no common law cause of action for wrongful foreclosure in Tennessee. Mr. Case has no remaining claims in this case. Therefore, we need a real issue of whether Fannie or Freddie Mac Uniform Tennessee deed of trust requires written notice of postponement in addition to an oral announcement, according to section 35.5-101 subsection F of the Tennessee Code. While Mr. Case has standing to bring his claims, we hold there is no common law action for wrongful foreclosure in Tennessee. Accordingly, we reversed the Court of Appeals decision in this case and remanded the trial for entry of an order consistent with this opinion. That order was to dismiss. And let me just say this. For you common law people out there, let me just say this. You common law people out there, please be aware that if you even say the word common law, in the Terry case versus Wilmington Trust 2024, that was a landmark decision. The Tennessee Supreme Court clarified, that was the Tennessee Supreme Court case I just read, clarified that the borrowers cannot sue for wrongful foreclosure as a standalone claim based on technicalities like securitization transfer errors, unless they can prove specific damages from a breach of the deed of trust or statute, which you won't be able to do. That's why they word it like that, because you are not a party to the securitization agreement. That's between the issuing entity who issues the mortgage-backed securities and its investors, who are going to be a lot of times institutional investors. So you're not a party to the securitization transaction, so you cannot raise it as a legal defense. I'm telling you something good. So if you ever get like a foreclosure, you don't, because you're definitely going to lose your home, and you're not going to win on appeal with that issue. I don't want that to happen to anyone. I'm just telling you. What they're doing online is they're going over these 2008, 9, 10, 11 cases where securitization, there was a small window where you could argue it and people were winning on their foreclosure defenses with that. But by the time 2013 came around, all those arguments have been foreclosed on appeal. So the appellate courts have issued rulings saying you can't use this anymore. So 13 years, people online have been arguing outdated, 13-year-old outdated foreclosure defenses at minimum for 13 years. See, this is something they won't tell you, though. I'm going to tell you. This is something they won't tell you. And everything that they read from is from 2006, 7, 8, 9, 10. Tell them to show you in 2023, 2024, 2025, 2026, 2020, 21, 22, from 2020 to 2026. Hell, for 2016 to 2026, the last 10 years where securitization argument has won in any court in the United States of America. You won't, because none exist. How about this? What about the late transfers? Late transfers into the remit. Put a 1 in the chat if you still believe that. TikTok, put a 1 in the chat if you think that a late assignment to a remit voids a foreclosure, meaning they can't sue you on the foreclosure debt. Just put a 1 in the chat if you still believe that. And we'll explore that with case law, not an article that I'm reading from. Let me know. Let me know. And whoever put your state. Put a state. Just put a state. You know what? He's a negative. No, bro. No, bro. They believe it. They be believing it. And I see them online every day, bro. I see them online every day. They will read from these old outdated. Here's another one. He said, I'm not falling for that again. Nah, I mean, bro, just about awareness, bro. I'm telling you, bro, these people are going to tell you things to do that they haven't validated, that they have never won on. And then when it goes up in smoke, they're not going to be anywhere around. They're not going to be sitting on the phone with you during your court proceeding. They're not going to be texting you. They're not going to be any. I just got a recent client for a foreclosure case, and she sent me her whole case file through these last 3 gurus turned on the file. If you look on my page, my very last post, I think it was, you'll see reference to tax forms on it. That actual document is what her guru with that lady put together for her to file on the record, asking for a 1099 form, and none of that applies in a foreclosure. 1099 forms are the reporting of income to the agency that administers the nation's tax laws. That's the IRS. That is the legislative branch of government, because they fall under Congress. That's not the judicial case law. And this is the problem what they do. They always bring non-court issues into the courtroom. You're in a court civil foreclosure case. You're not in tax court. Uh-oh. I just thought of another one. It's all a tax issue. If y'all don't get that 2009 Gene Keating talking points out of here. Freeman Samples. Enjoy Samples versus Bank of America. Successor by merger to BAC Home Loan Servicing and Countrywide. Now, this action is before the court on the motion to dismiss plaintiff's complaint submitted by the defendant, Bank of America, for failure to state a claim upon which relief may be granted. Now, the Samples, Joyce and Jeffrey, are the plaintiffs, right? Right. So they're the Samples. They're the plaintiffs in this complaint here, right? So let's go to second page. I don't know why it's doing this. Let me just download it. All right, here we go. I got it right here. So let's get down here. The plaintiffs borrowed $284,800 to purchase residential property. And they granted the lender a note in the deed of trust, right? From what the court can discern from the complaint, plaintiffs claims that Bank of America relate to the property, the mortgage over the property, various activities of Fannie Mae, the securitization process. Here we go. These gurus just talk about securitization, attach their SEC filings. The judge will figure it out for you. Yeah. Walking you right off a cliff. The securitization process, master trusts or special purpose vehicles in the operation of the MERS system. Plaintiffs filed the complaint entitled Complaint for Damages, Release of Lien and Other Relief in state court on December 12th, 2011. This is a 2012 case. Remember when I told you for around that time? So we right at the heels. Liberally construing the complaint, plaintiff seems to allege claims related to invalid assignments of the mortgage covering the property and claims that BANA, Bank of America National Association, has no right or standing to foreclose on the property and claims that BANA is not the holder of the note as a result of the securitization and purported splitting of the note in deed of trust. One thing where they got wrong from the beginning is the mortgage always follows the note. And gurus, instead of saying they bifurcated the note, tell your students the mortgage automatically follows the note. So if I sell you the note, the mortgage is already coming with it. So that means they only need to record the mortgage. Thomas, how do you know that? Look at your recorders. What are they recording? The deed of trust. Do they ever record the note? No. That should be an indicator. Now, the court has gleaned the following cause of action for the plaintiff's complaint. So you know what that means? When they say they got to glean it, when they got to construe it, that means they didn't put it in a legally intelligible form. So it looks like they just slap words together on the document. Kind of like what the last guru did with my new client. The court has gleaned the following causes of action for plaintiff's complaint: mistaken and erroneous representations as to standing to foreclose, unfair business practices, quiet title, and injunctive relief. Standard of review. See, every time they go over the procedural history of the case, now this is the part what I call the judicial light. Because now the judicial light is about to be shined on their arguments. In many cases, the arguments sound good until the judicial lights gets put on it. Under Rule 8A of the Federal Rules of Civil Procedure, a complaint must contain a short and plain statement of the claim showing that the pleader is entitled to relief. Number one, anytime the judge says that, it's an indicator that they didn't do that. Remember, ladies and gentlemen, in many cases, when they deny you, when you're getting denied out the gate, it's not because of the facts of what you're saying. It's because the rules of procedure wasn't followed. See, people think court is 98% of facts and how they saw how it went down. And the other two is the rules of procedure. Actually, it's the reverse. 98% of court is about rules of procedure. The other 2% is the facts of your case. Federal Rules of Civil Procedure. In 2007, the United States Supreme Court modified the pleading standard in the context of antitrust cases, and which is one of the cases I'm always telling y'all about, Bell Atlantic versus Twombly. The Supreme Court held that in order to survive a Rule 12b-6 motion to dismiss, which attacks the sufficiency of the complaint, the plaintiff must state a claim for relief that is plausible on its face. This means you file your complaint, they immediately file a Rule 12b-6 motion, meaning the complaint that you file has no legal validity from the jump. You would rather get a motion for summary judgment than a Rule 12b-6. Rule 12b-6 means that it was just, you was dead on arrival. And a lot of Rule 12b-6 motions that I've seen that these pro se people put together because their gurus put it together for them, a lot of those ended Rule 12b-6 motions. Now, in order to survive that type of motion, a complaint must contain allegations supporting all material elements of the claim. And they cite Bishop versus Luchin text here, 2008 case. In determining whether to grant a motion to dismiss, all well-pleaded allegations must be taken as true and must be construed most favorably to the non-movement, meaning on the other sides. Detailed factual allegations are not required, but a party's obligation to provide the grounds of its entitlement to relief requires more than labels and conclusions. Basically, they breached the trust. So since they breached the trust, they committed fraud. All right, next sentence. That's what they tell y'all to do. Citing Twombly at 555. A formulaic recitation of the elements of a cause of action will not do. Every court in the United States of America always says this. So basically, you are just, once again, when you're citing your complaints, just telling them what they did, what happened, and how wrong they did you. Nor will it unadore the defendant unlawfully harm me accusation. So that the defendant unlawfully harmed me, you can't just say they did. Prime example, fraud. Y'all like to use this a lot. Y'all love to use the word fraud in your complaints. Fraud, right? So fraud, you'll say, hey, they committed fraud by taking the vehicle and then answering my thing or bleeding or whatever, use fraud. What they don't do is say, hey, this was the servicer of the repossession vehicle. What did they do? They did this because the court under the statute, they're supposed to do this. The defendants did not do this. When? On this date. Where? This took place here. How it harmed you? It harmed me because under the rule, the who, what, when, where, how is never satisfied in these spaces when they use the word fraud. They're just going to use the word fraud. So when a person uses the word fraud, it doesn't have the 5 elements to satisfy. It lets me know that this is just a regurgitating talking point and not really a legal defense. A pleading must instead contain either direct or inferential allegations, meaning it can infer that it happened, respecting all the material elements to sustain a recovery under some viable legal theory. Plaintiffs are appearing pro se. Of course, because you only see pro se litigants argue stuff like this, word it like this, structure it like this. The allegations of a complaint drafted by a pro se are held to less stringent standards than formal pleadings drafted by lawyers, in the sense that a pro se complaint will be liberally construed in determining whether it fails to state a claim upon which relief can be granted. That means is, even though you may not be wording it correctly or putting it in the technical legal terms that lawyers would do, the judge will still kind of get what you're trying to say. So even though you're saying, you're butchering your statement, they still get what you're, this is what you're trying to say. We get what you're trying to say. And they'll take it as actually if you put it in a legal technical form. That's all that means. However, this lenient treatment, generally according to pro se litigants, has limits. Cited Pilgrim versus Littlefield, 6th Circuit, 1996. Neither this court nor other courts have been willing to abrogate basic pleading essentials in pro se suits. And this is why a lot of your pro se cases are thrown out at the beginning, because you don't get leniency when it comes to the rules and procedure of court. You get leniency on your complaints and how you're drafting it. You don't get a pass on the rules and procedure. You're going to be held to the same standard as they hold lawyers when it comes to the rules and procedure. Liberal federal pleading standards do not permit litigants, even those acting pro se, to proceed on pleadings that are not readily comprehensible. And yes, y'all, yes, I'm not going to say y'all because I don't know, but a lot of pro se pleaders from online, they think they eating. They are literally incomprehensible. As a matter of fact, let me show you how incomprehensible they are. Let's read something. I'm going to read what this, I'm going to read. We're going to leave it right here on this case, but I'm going to read what she actually, what this person actually sent to my client. We're going to read. We're going to read it. If I can actually find the damn thing. If I can actually find the damn thing. It's right here. All right. So, where we at? All right, let's go up. Let me show you. Let me show you exactly what she did. How she set my client up. Let me show you exactly how she set my client up. Actually, I'm going to go to the photos and pull it. It's right here in my photos. Let me show you how she set my client up. Let me show you how she set my client up. This was crazy. Now, where is she at? Let me show you where she at. Where we at? Where we at? Here we go, right here. So this is what she filed. Let me send this to so she says, IRS form 1099A, misused by Loan Depot to claim acquisition of the property under false pretenses. IRS form 1099C, wrongfully used by Loan Depot to, despite no legitimate debt cancellation, resulting in improper claims against the estate. IRS form 1041, Loan Depot failed to ensure this form was accurately filed, thereby infringing on the estate's tax liabilities and misrepresenting the financial status of the estate. IRS form 56, Loan Depot failed to properly submit this form, undermining the estate's control over its own financial interests. IRS forms 1099 INT, interest income. IRS form 1099 OID and 1040V. These forms were also misfiled, leading to an unlawful claim of interest and mortgage payments from the estate. Loan Depot willingly disregarded its legal obligation by unlawfully collecting mortgage and interest payments without the proper legal standing or submission of accurate IRS forms. This ongoing fraudulent misrepresentation violates both state and federal law. That is what is called, number one, is incomprehensible. That's called a threadbare assertion and conclusion. She said what they did violated state and federal law, but you know what they never do? They never have case law to support exactly the arguments that they made. They never have the statute to support exactly what they just said. They'll say it violates a law and then they'll keep it moving. That is what she filed. I immediately told my client, hey, listen, every document besides mine, you're going to file just a quick motion to withdraw the whole damn record. It is pathetic what these gurus are having y'all put on y'all mortgage cases. It is pathetic. Now, okay, so we already know that they didn't pass the pleading standards. Plaintiff's claims are dismissed as a matter of law. Plaintiff's complaint will also be dismissed because the cause of action asserted therein are unsupported by specific factual allegations and fail as a matter of law. You cannot tell the courts they just did this and did this. You have to prove with case law. This is my thing. They could give you all the goddamn advice in the world. Do this, file this, say this in court, do this, do this, do this. But when it gets to putting on paper, they have no case law to support it. If what they're teaching is so true, where's the case law to support it? Where's the overwhelming majority of case law where the courts have been consistent in ruling in the manners of claims as presented similar to what they're telling them to do? You know, hey, y'all know how to get them? Anytime they come on here and start teaching, just say, hey, when they start saying, hey, do this and do this, we're going to file this. I said, can you show me case law where the judge ruled in favor of this same claim that you're telling us to make? I guarantee you'll be blocked. Just start asking them that. Just start asking them that. Of course, they're not going to be like me actually reading from case law. Oh, they're not going to do that. But just, y'all ask them. That's all you got to do. Just ask them. Just ask them. Watch what happens, though. Don't expect to go back to your channel after you ask them, or expect to get gaslit or get cussed out or try to make a scene like, or try you derailing. Just ask a simple question. Don't be mean. Watch how they act. Their response is going to, once you see their response, you're going to be like, all right, the new culture empire is correct. He's right. Plaintiff's complaint will also be dismissed because the causes of action asserted therein are unsupported by specific factual allegations and fail as a matter of law. Plaintiffs allege that BANA made mistaken and erroneous representations as to BANA's right. This is Bank of America National Association. Right to standing and foreclose because BANA was not in possession of the note securing the property. Plaintiffs also challenged the role of MERS in the mortgage process, asserting that while ownership of the note may have been attempted to have been transferred, there's no evidence to support such transfer. Plaintiff also asserts that MERS acted solely as a nominee for the lender, and that MERS is not the holder of the note and had no authority to transfer. Plaintiffs also allege that there was a fraudulent or invalid assignment of the mortgage to Bank of America's predecessor, generally alleged misconduct pertaining to the securitization process. I thought they told you when to argue securitization, you're going to win. Can somebody get April or June? Where's April or June? Where's these mortgage securitization audits and mortgage securitization defense gurus at? Where they at? Where they at? They need to read this. You know they're not going to show up. See, they're watching from the outside right now. It's 6 of y'all in here. It's probably about 40 or 50 watching from the outside. You want to know why? Because they don't want to click in live, because some of y'all will spot them from teaching the same things that I'm reading that the court is invalidating. See, they know they ain't stupid. They're not going to step their ass in here, but they're going to watch from the outside where you can just click and say watch live. No, they're going to watch from the outside, what they're doing right now. So while y'all watching from the outside, you mortgage, auto, foreclosure gurus, this is for you. All right. Plaintiffs also allege that there was a fraudulent or an invalid assignment of the mortgage to Bank of America's predecessor, generally alleged misconduct pertaining to the securitization process, and alleged that Bank of America's conduct constitutes unfair business practice. Lastly, plaintiff alleged cause of action for quiet title and for a preliminary and temporary injunction. It is well settled under Tennessee law that any assignment of the note automatically transfers beneficial ownership of the accompanying deed of trust, which goes back to what I just said. The mortgage follows the note.
You're rocking with the best.
Huh?
You're rocking with the best.
Huh? Well settled law. You know what that means? You ain't already know that? What? You thought that it matters because the mortgage was bifurcated for the note? See, that's where that fraud stoppers, that website got your ass up Shit's Creek too. A lot of y'all been tuning in. Remember that fraud stoppers website? Y'all can't fraud stoppers. Oh yeah, they bifurcated the note and the mortgage must follow the note. Then they bifurcated, they split it. So now you have a note with no property to secure it. And you have a security interest in the property with no debt to enforce it. Well, for you bifurcation, they split the mortgage and note. I'm going to read it to you one more time. Now, gurus, don't leave right now. Don't go search for those videos or try to take them down, because I noticed quite a few of y'all started taking your old videos down after I came out and spoke about it from a legal standpoint. I know y'all started taking those videos down. It's all good. All good, though. Leave it up. You should want to leave it up so people can see the growth. When you finally get to the level from a professional standard, they can see the growth. Don't take it down now, because it just shows that you're just doing shit to make money. Nah, leave them up. Trust me, I've downloaded a few of them already. It is well settled under Tennessee law that any assignment of a note automatically transfer beneficial ownership of the accompanying deed of trust. See WC Early Company versus Williams. When was this law settled? Just guess what year, TikTok, do y'all think this law was settled? Just guess what year. The controlling case on this is W.C. Early Company, EARLY Company versus Williams. 1916. It's been settled law since then. So it goes back to that bifurcation. Where did that come up? Who created that? The same individual who created the secret trust fund account based on that social security number and birth certificate. Roger Elvick started that myth, and it just spread like wildfire. My bad, y'all. I ain't mean to say that. Yeah, that was created by Roger. He was the first one because in the beginning, it was an exemption account. Then it came, remember the exemption account? Your social security number without the dashes? It was an exemption account. Then it became a trust account. Then it became the estate. You see how it taking on different names? They use different names to describe it, but it still has the same underlining meaning. So there's no difference between the ideologies of someone saying my exemption account, which they were saying in the 90s, late 80s and the 90s, till today, the estate. It's no different. Your estate is all the property and assets that you own, especially at the time of death. Everything that you own, that's your estate. That's it. It's nothing ethereal. It's nothing that you're just floating out in space somewhere. It's something that can be tracked. And for the love of Jesus H. Christ, a CUSIP number identifies a security only. It does not provide any type of beneficial ownership or any entitlements to payment just because you have a CUSIP number. Please do not put those on your tax returns this year. Please don't. It's going straight in the shredder and you're going to get hit with a bill. You're going to get hit with a frivolous filing telling you to withdraw that garbage, or you're going to get hit with a $5,000 penalty. When you get hit with that $5,000 penalty, don't go to the next guru to try to clean it up. Go back to the same guru that you paid money to fix it. In this case, quoting, it is well settled rule with us that the lien of a mortgage or trust deed passes without a special amendment thereof to the endorsee of a note or transferee of the debt secured by the instrument. Clark versus Jones, 1894. The transfer of the note without more carried with it the lien created by the deed of trust. So the new culture empire has informed y'all that if you hear anyone talk about, oh, they split the note and try to make an argument out of it, or you just say, we got well authority that is not true. And if they still tell you it's true, then you already know. The role of MERS in the mortgage process has also been validated by many courts, including those within the United States Court of Appeals for the Sixth Circuit, stating that courts have uniformly approved the role of MERS in mortgage transactions. And there's just a plethora of case laws. In this case, Ciardi versus Lending Company, Inc., the court dismissed the argument that the mere listing of MERS as a beneficiary renders the deed of trust invalid. That is another social media online myth. Furthermore, plaintiffs acknowledged in their complaint that per plaintiff's deed of trust, MERS has legal title and may act as nominee for the lender and its successor in the signs. Why do you think they set up MERS? And you see, these gurus, they're so quick to tell y'all stuff, but they don't even stop to think to realize how ridiculous they sound. What does the acronyms even stand for? Think about it. For all you want to see the wet ink and a wet ink signature on the note and deed of trust, just like a guru just put a video out just for clicks and views for my take. You need to see the wet ink signature on the note and deed of trust, right? Okay. All right. You want to see that? Here's your answer. Mortgage electronic registry system, MERS. They don't ever need to have the original copy anymore. Everything today is electronic file. This is why it's either going to get, remember, you'll get the electronic copy. It says that. Y'all know y'all be seeing the electronic copy too. Stop acting like you don't see it. Or the authoritative copy. The originals are destroyed. As a matter of fact, the Federal Reserve tells them, send us the electronic copy, destroy the originals. It's all part of the Paper Reduction Act. Nobody wants to be hauling around 50,000 pages of original notes and deed of trust when you can store it in an electronic database. So all they can do is just send it to you. You can print it right out. That's all it's there for. They can go right to the database and print it out. You need a copy, they'll just print it out for you. They're not holding the original. So that's another myth. The wet ink signature, wet ink deed of trust signature, it won't get you nowhere. Now, several courts have noted that such language especially grants MERS the power to act as the agent of any valid note holder, including assigning a deed of trust and enforcing the note. So the problem with MERS was they were enforcing foreclosure actions without having the authority to do so from the note holder. As long as the servicer, and I don't give a damn if it's the servicer, original lender, MERS, the bank, the SPV, the trust, Bob's ABC and Accounting, Jimmy John's Securities Corporation, the down the corner liquor store owner, the owner of Wells Fargo, the Applebee's CEO, you or me. If we have the authority from the note holder, we can foreclose. See, that changes the arguments, don't it? It changes how you look at the argument now. I know it does. Plaintiff has also offered no legal or factual allegation or basis for disregarding the deed of trust signed by plaintiffs. Accordingly, any claims plaintiffs have attempted to assert based on an invalid assignment, to the securitization trust or the roles of MERS in a mortgage transaction will be dismissed. Nah. They didn't say will be dismissed. They said will be dismissed. As noted, the lender or any party that succeeds the lender as the holder of the note is the beneficial owner of the deed of trust, with MERS serving as the nominee. See, this is one of those moments where even though they tell you something different, you believe different, this is one of those moments where this is just what it is. All courts are universal on this. This is what it is. Accordingly, plaintiff's argument that the deed of trust is defective because it was split or severed from the note is without merit. Plaintiff's argument that Bank of America improperly foreclosed on the property because it was not the holder in due course is also not well taken. Under Tennessee law, a holder in due course is a person who takes a negotiable instrument such as a promissory note for value in good faith and without knowledge of any apparent defect in the instrument or any notice of dishonor. Now, what UCC negotiable instrument do you think they're citing for all you people that's saying on my UCC part 2 that you're wrong? What are they saying when they say C? When a person that takes a note, that's a negotiable instrument. We own negotiable instruments, UCC, for value, good faith, and without knowledge of any apparent defect in the instrument or any notice of dishonor. C, SEE, like they're about to give you the reference to where they got that from. Where do you think they're citing there? Do you think they're citing LexisNexis UCC 3-103? Do you think they put UCC 3-103? You think they put that there? Let me tell you what they put there. C, Texas Code ANN 47-3-302, meaning they're referencing the UCC under state law. They're talking about state law, statutory law. So for you, oh, you're wrong. You're wrong. But I'm so tired of you fake sovereigns, you fake, I know it all motherfuckers. Y'all come, just drop your comments. You're wrong. And nothing to back it up. Everybody that commented on the Admiralty video saying I was wrong, everybody that commented on both of my UCC and statutory law videos, none of them substantiated it. All of them that commented are wrong. And this goes to show, and I make those videos like that on purpose because I know people, it's going to get their attention. They're going to comment. And it goes to show how lost many people are in these spaces. But they think they're so close. They think they got it all figured out. They don't even understand. They would have to unlearn everything that they learned in order to have a remote chance of getting any close to the promised land. Nah, but they think they're right around the corner. Plaintiff has not alleged that Bank of America or any other party was assigned the promissory note without value. In the absence of good faith or with knowledge of any defects or notice of dishonor. Accordingly, plaintiffs lack standing claims premised on Bank of America not being the holder in due course will be dismissed. Plaintiffs claims that Bank of America engaged in unfair business practices in violation of the disclosure requirements under Section 1632 and 1788(3) and 15 U.S.C. Chapter 41, Section 1692 and 12 U.S.C. Section 2601 and 2617. God damn, these are a lot of statutes I see these online gurus talking about every day. Uh-oh, they should win. They should win on this argument. And plaintiffs' claim to quiet title will also be dismissed. Good God, everything that they teach and getting spanked in this court case. Sheesh. Plaintiffs have failed to allege what the alleged wrongful business act or practice was under each statute, as in statutory law. I told you, what did they do? They'll tell you fraud. Oh, unfair business. Think about it. They'll tell you just to say it. Oh, unfair, deceptive business practice. But give you the elements on how it was. And if you ask them, well, how? They're going to give you what they believe instead of what the statute requires. Plaintiffs have failed to allege what the alleged wrongful business act or practice was under each statute, who was alleged to have committed the wrongful act or practice, when the wrongful act or practice occurred, and against whom the wrongful act or practice was committed. Plaintiff also fails to discuss or describe the statutes they have alleged Bank of America to have violated because they never do it. They never back it up with actual factual evidence. They never do. They never do. I'm talking about people online today, just pro se community today, rarely ever do. Plaintiff also fails to discuss or describe the statutes they in support of their quiet title claim. Plaintiffs allege that Bank of America has no right, title, interest, or estate in the property. However, plaintiffs have alleged no allegations of fact supporting this claim, and given the court's dismissal of plaintiffs' claims premise on whether Bank of America has standing or right to foreclose on the property, this claim will be dismissed as well. Working on a clean sweep, ain't we? Last, the court turns to plaintiff's request for preliminary and temporary injunction. Oh my gosh. Then one of the number one things of Rule 65, they made credit acceptance respond to my Rule 65. I know what you're about to say. So what? Go file a Rule 65 motion and see how easy it is to even get them to respond to it. Go ahead. In order to grant a preliminary injunction, a district court must consider whether plaintiffs have established a substantial likelihood or probability of success on the merits. That's the number one thing. If you want any indicator of how your complaint is going to turn out when you file it, Once you file your complaint and then you file a motion for temporary restraining order, injunctive relief, if the court orders them, if there's not like an immediate emergency, they won't place a temporary restraining order. They'll just give them, tell them to respond. It's usually like within a week or so. But if you want an indicator on how your complaint is going to do, go file your complaint and they're going to file a motion for temporary restraining order. If they deny your motion for temporary restraining order, that's an indicator your case is going following next. Because the biggest thing is, in order for us to grant or even make them respond to your motion for temporary restraining order, you must prove that there's a likelihood of success on the merits of your original complaint. Okay, let me just take the gloves off. If your motion for temporary restraining order gets denied, that means your complaint is going to get denied too in the end. Let me just be clear. That's what it means. Whether there is a threat of irreparable harm, whether the issuance of injunction would cause substantial harms to other, and whether the public interest will be served by granting the injunctive relief. Plaintiffs have not provided any showing that these factors weigh in favor, and thus, after due consideration, the court finds that all of the factors weigh in favor of denying plaintiffs' requests for injunctive relief. And just like the rest of them, these claims will be dismissed. What's up, girl? What's up? What's up, Red? Ready, Red? What's up, Ready, Red? Does anyone know the case he's reading so you can pull it up? Yeah, you can pull it up. Conclusion. For the reasons stated above, Bank of America's motion to dismiss will be granted. Plaintiff's complaint will be dismissed. And the clerk will be directed to close this case. An appropriate order will be entered. Well, this is Freeman M. Samples and Joyce R. Samples versus Bank of America. This case took place, I think, in 2012. Samples versus Bank of America. And there were quite a few things that they said in that case that you will still see online today. So, hey, listen, man.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
And, it is what it is. Now, these are the people whose complaints are just dead on arrival. There are, like I said earlier, there are times where the judges will get it wrong. They do get it wrong too. But in cases like this is the majority of what you see online. See, the judge being wrong and not applying the law correctly, you ain't got to worry about those arguments here. Because these were just all dead on arrival. And what I'm bringing awareness to people so you can stop blindly following these people just because you got everybody in the comments agreeing with them. Just because they jacked up the numbers and look like they got 20, just because the person has 21,000 followers does not mean that they know what they're talking about. It just means many people and that like their content agrees with them. They believe with it. This is a belief system thing. This is not a factual basis space. TikTok is not a factual evidence basis space. It's a belief system. Trauma bonding. We all think alike, so it must be true space. This is why you don't see a lot of these TikTok gurus on YouTube, because they would get called out for it. They run over to TikTok and hide. Do you know how many professionals be scalping these spaces to make content out of? Professional tax preparers and planners. Do you actually think Vincent Edwards would ever be live on YouTube breaking down taxes? He will get scalped over here. YouTube is the end all be all. If you can't make it on this side, people run to TikTok. It's like Leah Daniel. She's sovereign citizen through and through. She got her ass on YouTube. Where she run to? TikTok and Facebook. Because that's the melting pot for sovereign citizens and people who believe like that. Those two are the melting pots. You'll never see them on YouTube. See what happened to Mika? She don't be on YouTube no more. Miss Jackson, she ran her ass over the TikTok too. They're all running their asses over here on this app. Skip the balls. You don't see them over here. TikTok. They hide on TikTok. They try to rebrand their names. They try to rebrand their names. Take their real names down. Put some "let's go" up and have avatars trying to rebrand. Or they start little Telegram groups. Like I ain't got screenshots. Hey, the IRS sent me a letter asking for the money back. They now say I owe $201,000 plus 5,000 penalties. Yo, they asking for last year's and the years before check back too. Now they say I owe 600,000 back. Help, please. I know. Everything ain't glitters is not gold. If you think you're going to file a 1099-B with those large withholdings, filing it in the name of the company and putting you down as the recipient, and you're sending one to the IRS and then you're filing your copy with your return, they're going to verify that income. The finance company actually send that money to the IRS as a withholding from your proceeds? Huh? Did they pay those taxes on your behalf? Because if they did legally, you will be getting a form. Huh? How can you validate that withholding when the reported income, you only made $32,000? How can you validate a $200,000 withholding? Make that, just look at the numbers. The numbers itself is going to flag it. And for those who bypass the system, see, you think you bypass. See, the IRS just don't come back in 90 days. Oh, no. Sometimes they'll catch it fast. They'll reverse the account immediately. Sometimes they'll come back in 90 days. Sometimes they'll come back in a year. Sometimes they'll come back in 2 years. But one thing about it, if it's not legitimate funds and it's not legitimate holding, they're going to check the traps. The question is, what are you going to do when they come back? Are you going to give them the money back? Remember, money ain't shit. Remember, you always say gold and silver is the lawful money. Remember, isn't that the argument? Money ain't shit. You know what I believe? I believe everybody that says money ain't nothing, these SAR and all, barter and all this, those are the ones who chase it the most. Those are the ones who chase it the most, and those who are in vulnerable financial situations chase those processes the most. Want to know why? Because from the screenshots I got and the transcripts I got from my inside man, hey, inside man, you like that, boy. You be infiltrating these groups and be finding that shit, boy. You like that, my inside man. Common theme for what I see: income reported, legitimate income reported. 30,000, 40,000, 27,000, 17,000. What's the withholding? 45,000, 60,000. So I started putting people in classes, and you're financially vulnerable situations, and those who are motivated by greed are the ones who does those things. Oh, another thing. If you think you're going to make a fake W-2 this year too, they're on the lookout for that as well. They're on high alert for all fraudulent 1099Bs with your 1099A and your 1099 OIDs. Yeah, they're on high alert. Just to give you a heads up. If you was thinking about sending it in, don't do it. Don't do it. I got a question. If you want $100,000 so bad, what's wrong with going out in the real world and putting yourself in a position to go get it? What's wrong with that? Why are you relying on tax form to like secure you? Think about it. The reliance on a tax form to secure your future, to get you out the financial hump. Who got you in the financial hump? Did you get yourself in the financial hump, or life decisions got you in the financial hump? Then why are you relying on the government to get you out the financial hump? Because what I never see is income reported 130,000, 175,000, 200,000. verified income reported on the tax return, W-2s and stuff. I don't see that amount. But I always see those amounts in the withholdings. Why is that? What's the difference between the hours that we get in a day, the days, the weeks, and months, and the years that we get? Why throughout the course of these last 3, 4, 5 years, you couldn't start to see that on your own? What's wrong with that? And why do people look at the IRS as someone to refund you your mortgage and auto? Why do you think that's their job? When the IRS administers the tax laws and the refund is always from an overpayment of taxes, what makes you think that the mortgage company or the auto company withheld your proceeds and sent it to the IRS for you? What makes you think that happened? Because anytime I get a 1099-B legally, it's for money that I've already received. You know what that means? There's rarely ever any withholding on a 1099-B. Very little. Unless there's a backup withholding situation. So unless it's a backup withholding, why are they telling you to put 24% on your 1099-B? Doesn't even make sense. It's not even in line with the rules and regulation of the IRS. There's nothing in the IRS that says you can do that. Oh, let me guess. They pop up in a business suit and their arms are folded and then a corporate background and it look like legal business. Or they're showing refunds approved and they tap you in like that. But are they showing you what happens behind the scenes? No. No. So all I got to do is say, I got an execution class. You give me $1,000 now, I help you get $100,000, $200,000 back. See, many people don't look at, well, hold on. That sounds a little too good to be true. Hold on, what's the back end? How's it go? No, only thing they see is $1,000 for $200,000. That's all people see. And then when it blows up in their face, there's going to be no accountability. They're going to snitch on the whole operation. They're going to snitch on the Telegram group. They're going to snitch on who's told them. They're going to snitch. Want to know why? Because that happened last summer. Oh, they was getting big checks. 400,000, 500, 100, 30, 80, 90 for their clients and for themselves. Guess what happens when it blew up in their face? The client snitched on the whole operation, told them exactly what they did, told them, and then they told them that they helped them how to hide the money from the IRS, and then try to help them prepare documents to keep the money. Part of a major indictment. Pretty sure y'all heard of the Telegram group. It's a husband and wife, and they seized everything. The government took everything. Wire fraud, mail fraud, and all these generational wealth people on here. I stand by my word. The only reason why you want that money so you could be a big consumer. You're not going to buy any. You're not. There's going to when it's all said and done, there's not going to be nothing to show for it, because you're going to be so busy trying to live like the Joneses and have the things with that money that you can't get now, that you're going to give a damn about generational wealth. Sorry to the people who actually think like that, generational wealth. But the way they butcher that term, I don't even want, anytime I hear someone say generational wealth, I already know, oh, consumer, they're about to get that money and go spend it on big. What are you actually going to spend it on anyway? What are you going to go do? Get a vehicle, take trips, buy this, all consuming. You ain't going to go participate in the same system that makes billions of dollars off us. You ain't going to flip the script. I said, well, shit, let me go ahead and give him a piece of this pie. Let me get some of these mortgage-backed securities over here. Hell yeah. Let me take 150,000, spread it all around, plant seeds everywhere. Oh no, 150,000 gonna go to a new vehicle, probably get a new place, get a new wardrobe, get the hair slayed, go on vacation, go to the restaurants. Go buy shit so everybody can be, so you could be online. Look at me now. Go buy shit to be like, look at me. Can't wait to post. What's that check? Can't wait. And since you didn't work for it, you really don't respect it. You really don't appreciate it. So the mindset is going to be, I'm going to fuck this money off now. I'm going to fuck this money off now because I can go back next year and do it again. You ain't building up no nest egg. You ain't investing in nothing that's going to bring you receivables and cash flows off that seed money. You ain't going to do none of that. So when it blows up in your face, that's when you're going to be like, damn, I ain't really do shit with my money when I had it. When it was all good, I ain't do shit with it. And that's 98% of the people who take those classes. That's the mindset. Anytime someone offers you free money in these spaces, you have to initially put up red flags because there's no free way to get any money out the United States government. Y'all should know that by now because you never access your estate. You still think it's there. You still believe it's there, but you've never accessed it. Newsflash. If it was actually real, people would have been accessed it. See, you think this is new. That estate, birth certificate, account number, all that, that's like a 40-year-old theory. Literally 40 years. People have been trying to grab it, tax it, to get it for decades. No one has been successful. Many people have failed and went to prison behind it, but no one's been successful. People went to prison behind these bills of exchange. People went to prison behind these international promissory notes. People went to prison behind these bonded promissory notes, these registered bonds that they're still online today selling. But this is supposed to be about freedom, asserting my rights. No, it's not. It's not about asserting your rights. Stop saying it. It's not. It's about getting something for nothing. It's about getting something and not being responsible for it. It's about getting things for free. It's about being absolved from all accountability. It's about doing what you want, making the decisions that you make and not have to suffer any consequence. That's what you think this space is about. You are going to be in for a rude awakening when reality smacks you right in the face. And if you don't wake up and understand what's really going on, you are going to find yourself in the middle of nowhere with nothing, wondering, how the hell did you get here? Because this space has done more than to destroy people's lives than it has ever done to help. Than it has ever done to help. It has done more to destroy people's lives than it has ever done to help. You think I haven't talked to these people? You don't think I've spoken to these people who has felt the brunt? People who has lost their homes and their vehicles pursuing these claims these gurus said make? Oh yeah. Mr. What's your name? What's your name? I got you. Or you're next on the chopping block. What's your name? What's your name? Boris off Rumble. Mr. Boris. What is it? Boris Law or Law? Boris Knows Law off Rumble. I got your video from the class you just taught. I got your videos from the class you just taught, Mr. Boris. Yep. You are on the chopping block as well. Yep. I got you. Don't worry. Don't worry. I got something special brewing for you. And you know me. You know me. I'm not going to talk about you. I'm not going to talk about what you do. All I'm going to do is take your talking points and what you're teaching, and I'm going to throw them up under the judicial light. I'm going to tell you what they're saying, you're saying, and then I'm going to show you exactly how it really goes when it plays out in court. Are you bankruptcy teachers out there? I got something for you too. Are you foreclosure teachers out there? Got something for you too. Are you auto loan? And that's the biggest one. Autos. Get out your autos. Get out your autos. Get out your autos. Got something for you too. Because I doubt if they were ever able to save their own selves by the same stuff that they teach. They got the remedy for everybody else, but never seems to be able to save themselves. You can pull the speck out my eye, but you can't seem to get the plank out of yours. Have you been successful before? The answer now can't be a yeah and keep teaching. No. The answer now, show me your title based off the merits. Show me your title. Let me see it. Not an application of title, not some of these trust processes where they tell you to transfer your title into a trust while it still has a lien on it. Nah. Show that they issued you the title without the lien on it. That's what y'all need to be asking them. If you're in any group where you're scared to ask a question because you don't know how they're going to respond, YouTube, see y'all later. If you're scared